Every year, billions of dollars cross international borders, not as trade or investment, but as charitable donations. Some build hospitals, some educate children, some help communities recover after disasters. But one question continues to divide democracies around the world. Should foreign money be allowed to influence organizations operating inside another country? Supporters say international funding helps solve humanitarian problems. Others argue that without proper oversight, foreign funding could be misused to influence social, religious, or even political activities. This debate isn't unique to India. Countries including the United States, Australia, and the United Kingdom have laws addressing different forms of foreign influence or foreign funding. Now, India is proposing another major change through the Foreign Contribution Regulation Amendment Bill 2026. What exactly is changing? Why has it sparked debate? And why is the world paying attention? Let's examine the facts. India first introduced the Foreign Contribution Regulation Act, or Fcra, in 1976. The law was replaced by a new act in 2010, followed by important amendments in 2020. The government says the purpose of the law is straightforward: to regulate foreign contributions so they are used lawfully, transparently, and in a manner consistent with India's national interests. Organizations that wish to receive eligible foreign donations, including charities, educational institutions, research organizations, and certain faith-based organizations, must comply with the requirements of the Act. Millions of Indians benefit from work carried out by such organizations every year. India has one of the world's largest non-profit sectors. Many organizations work in education, healthcare, disaster relief, child welfare, women's empowerment, environmental conservation, rural development. Some rely entirely on Indian donations. Others also receive financial support from individuals, foundations, charities, or institutions located outside India after obtaining the approvals required under Fcra. For many communities, these organizations provide services where resources may otherwise be limited. Over the years, the implementation of Fcra has become the subject of significant public discussion. According to the government, investigations in some cases identified alleged violations of Fcra provisions, including alleged non-compliance with reporting requirements, alleged misuse of foreign contributions, or alleged use of funds beyond the purposes permitted under the Act. As a result, the Fcra registrations of numerous organizations have been suspended, cancelled, or not renewed under the legal process. Another issue frequently discussed in public debate is religious conversion. Some political leaders, state governments, and commentators have alleged that certain organizations used foreign-funded charitable activities to encourage or facilitate religious conversions. Supporters of stricter regulation argue that these allegations show why stronger oversight is necessary. At the same time, many NGOs, churches, charities, and civil society organizations reject these allegations. They state that their work consists of lawful humanitarian assistance, healthcare, education, disaster relief, or constitutionally protected religious activities. Some organizations have challenged government actions before Indian courts. Each case depends on its own evidence, investigations, administrative decisions, and judicial review. For this reason, allegations relating to specific organizations should not be treated as applying to all NGOs. This is where the proposed bill introduces some of its most significant changes. 1. A new designated authority. The bill proposes creating a designated authority. If an organization's Fcra registration is cancelled, surrendered, or ceases because it is not renewed, this authority would supervise and manage foreign contributions and certain assets created using those contributions as provided under the law. 2. Assets created through foreign funding. The bill proposes a legal framework for assets such as schools, hospitals, welfare centers, research facilities, or other property created using foreign contributions. Supporters say this helps protect assets purchased with foreign funds and ensures they continue to be managed within a legal framework, Critics argue it could increase government control over NGO assets. 3. When registration ceases. The proposal clarifies situations in which an Fcra registration is considered to have ceased, including cancellation, surrender, or non-renewal. These situations may trigger the proposed asset management framework. 4. Prior permission becomes more specific. The bill proposes that prior permission to receive foreign contributions should relate to a specific purpose, a specified amount, a prescribed period. The government says this is intended to improve accountability. 5. Restrictions during suspension. If an organization's registration is suspended, the bill proposes restrictions on selling, transferring, mortgaging, or otherwise dealing with certain foreign-funded assets without the required approval. 6. Penalty changes. The bill also proposes reducing the maximum imprisonment for certain offences under the Act, while continuing to strengthen oversight and compliance mechanisms. At the time of this documentary, these are proposed legislative changes that remain subject to the parliamentary process. According to the government, the proposed amendments are intended to improve transparency, strengthen accountability, protect assets created through foreign contributions, prevent misuse, provide greater legal clarity. Government representatives have also stated that regulating foreign funding is consistent with the sovereign responsibility of a nation to oversee money entering its jurisdiction. Critics, including some NGOs, legal experts, and civil society organizations, have expressed concerns about the proposals. Among the issues raised are whether the new asset management provisions could affect organizational independence, whether additional compliance requirements could increase administrative burdens, and whether legitimate humanitarian organizations could face operational challenges. Some international human rights and civil society organizations have also commented on India's broader Fcra framework. India has responded that foreign funding regulation is a matter of national sovereignty and that many democracies maintain their own legal frameworks governing foreign influence or foreign funding. The Fcra Amendment Bill 2026 is not simply about foreign donations. It is part of a much larger conversation taking place across democratic societies. How can a nation welcome genuine humanitarian support while ensuring transparency, accountability, and protection of its national interests? Different countries have answered that question in different ways. India's answer continues to evolve through its democratic legislative process. Whatever the final outcome, one thing remains clear. Understanding the facts rather than assumptions is essential to forming an informed opinion. Thanks for watching Wealth Chronology. See you on next video.